Tune in for Series 5 of the HIP Talks, a podcast series of discussions on legal issues hosted by Hugill and Ip Solicitors, an independent boutique law firm in Hong Kong, providing bespoke legal services and exceptional client service to individuals, families, entrepreneurs and businesses, both locally and internationally. The forthcoming podcasts are the Barrister series. Over 6 episodes, the team sits down with preeminent Hong Kong barristers to discuss contentious issues related to civil litigation, employment, family, trusts and estates, as well as increasing awareness about the importance of the role of barristers in court proceedings and the relationship between solicitors and barristers when acting for clients. Hugill and Ip provides expert advice across a variety of dedicated practice areas, both contentious and non-contentious. An outstanding team of solicitors who have achieved exceptional results and recognition in the areas of dispute resolution, probate and trusts, family and matrimonial, corporate and commercial, and employment and immigration. Hugill and Ip applies modern thinking to legal services, uses technology in a contemporary office environment, and is fully committed to giving back to the community.
Good morning. I'm Adam Hugill from Hugill and Ip Solicitors. I'm here today with Frances Lok from Voeux Chambers. Hi, Frances.
Hello, Adam.
Hi. Thanks for joining us today to be part of our Solicitor Barrister podcast series.
Thanks for inviting me.
It's a pleasure. We've known and worked together for about 15 years, and I think we've had a number of interesting cases that we can talk about later today.
Yes, we have. You're one of my earliest instructing solicitors, in fact.
Fantastic. Let's wind back to the beginning. Before you were even a barrister, I understand that you studied at Chinese University, classical Chinese.
That's right.
And did that inspire you to have a life in the law?
Well, that did not, but I was very active in debate. That's what gradually led me to the law.
Okay, and after that, you did a master's at Oxford, and then, because one master's isn't enough, another master's at Harvard.
No, actually, I did my degree in Oxford,
okay.
And then the master at Harvard.
Excellent. And how did you find living and studying in the UK and then in the States at such a young age?
It was very challenging at first because that was a very big change from studying Chinese, obviously. But that was also very satisfying. I immensely enjoyed the tutorial systems, as in you cannot really escape from doing a thorough research before taking any classes because it's usually one-on-one. And you have to thoroughly know your subject before walking in.
Very intense.
Yes, very intense. And the finals was quite a live experience because you know that they have to take the entire exam of all subjects in the end of your degree, usually within a week or two. So that was really intense as well.
Yeah, I went to a much easier university. So we split hours over the second and third year.
But that was very good training, really. The other thing is that they take the exam of every semester after the long break. So you have to train yourself to be very disciplined, to do your revision at the same time, but enjoy your holiday.
Okay.
Yes.
So that's very good training for the bar, where you have to be very self-motivated and disciplined.
Exactly, but not to lose sight of what you need to do in your life in general, apart from work, obviously. That is very good life training for me.
Fantastic. So work-life balance, even whilst at Oxford and Harvard. Okay. So this didn't put you off because you qualified in both Hong Kong and at the New York bar.
Right.
What inspired you to choose Hong Kong over the New York bar, or was New York bar just a sort of qualification that you acquired for good measure?
Well, I do feel very committed to Hong Kong because this is the place that I grew up in, and I feel indebted to a lot of the people who helped me on the way. I got the scholarships to go to studies overseas, and as part of the commitment, I come back and develop my career back in Hong Kong.
Excellent. And you started as a pupil at Voeux Chambers?
Yes.
I've been at Voeux Chambers ever since?
Ever since. It's a very long time.
I know it's on your website, but how many years is that?
I think about 17 years, almost.
17 years. Fantastic.
Yeah. And in fact, I feel very indebted to some of my mentors in Voeux Chambers because they were the one who reached out to me when I was studying in England and said, why don't you come here and have a look at our chambers? Why don't you become my summer pupil? So I started my internship at Voeux Chambers in my second year.
And you have to go through four pupillage or four pupil masters, is that right?
4 pupil masters. In my days, it was still 4 different seats. So I finished 3 seats in Voeux and 1 other seat in another set of chambers for criminal practice.
Okay. I remember back when I was at that similar sort of stage, working out what path I wanted to be a lawyer, but to work out which path to take. And the idea of joining the bar filled me with absolute terror, because I would be a young 20-year-old in those days in London, trying to make my own way as a self-employed person. I just had no confidence that that's something I could do. How did you have the confidence that it was all going to be good? Because I think the Hong Kong system is that you're essentially unpaid from day one and you just have to make it on your own.
It was a big decision to make at the time, as you put it, because of the financial burden that you have to face. You do have to fund yourself through PCLL as well as the pupillage. But I was very lucky because I got a scholarship to take me through those hard years. And that's why it afforded me the choice of doing what I like. And to tell you the truth, the adrenaline rush of going to the court really motivated me in a way. I found that kind of work really more interesting than the other side of the work.
So being a commercial solicitor, sat in a big shiny tower, just doesn't have the same adrenaline rush.
Well, let me tell you the truth. I did some internship in some solicitors' firm, but they put me to do some due diligence on some conveyancing work. Maybe that was why, as a very young self, that I was far more attracted to the company's court and the court hearings, etc.
Fantastic. And so you've just said that your practice is company and commercial law. Was that always your focus? Did the criminal bar ever hold any attraction to you, or the family bar? Was it always business?
It has always been business.
Well, it's been great to have the opportunity to work with you. As an employment lawyer, I sometimes consider myself to be on the business side of things. And nearly all of the cases we've worked on have had a family angle to them. Perhaps apart from the very first one. I don't know if you remember back, probably to 2010. But the very first case we did was an Anton Piller.
Yes, it was. Very exciting.
Do you want to tell the world what Anton Piller means?
Anton Piller is a form of mandatory order made by the court for the delivery up of documents. Generally, this kind of order is made at a time when there is a risk that relevant information in relation to a court case will be destroyed. That was actually our first case, wasn't it?
I think so. The thing about Anton Piller is it's probably the most exciting thing you can do as a solicitor, because you get out of the office. Essentially, it's a civil form of search and seize.
Yes, it has been described as the nuclear weapon of the law.
Nuclear weapon indeed. And so once the order's made, when you flip to the solicitor side, we've got all of the work to do. I know you do all of the legwork to get us there, and it's intense. But once we've got the order, then we have the opportunity of, in the case we did, it was an office, I think in Jordan, where we get to not exactly bash down the door, but get our foot in the door, take control of the office, take all of the papers. It's very exciting. I did one in the UK that was much more emotional, where we had to raid somebody's house. And so we had to go through the kids' bedrooms and things like that. That was quite emotional as a junior solicitor to do this.
I think this sort of order, it demonstrates how important it is for our side, the barrister side, to work closely with the solicitors, because it is very important to get an order that is not only enforceable but also workable. So we have to actually walk through each and every details in seeking as well as drafting up the order before we actually go into the courtroom and get it. Otherwise, we'll get an order that is not quite useful for you guys. When you have to, take the piece of paper and go and do the work, you have all sorts of practical difficulties.
Exactly. The other side solicitor arrives very quickly, scours the order and finds the loopholes.
Yes.
When we apply for injunctions, usually we have very little time as solicitors, but as a barrister, you have even less time. Because sometimes we see these things coming from a few weeks away, sometimes a few months away. But when we call you, it's usually when we need you to jump on it with less than 1 week, sometimes 2 or 3 days.
Yes. On my record, you are the one who invariably calls me before the day of Christmas.
Yes.
I think 3 years in a row, I was always expecting before Christmas, when will Adam call me? And then,
Is he here to wish me Merry Christmas?
And then he's like, hey, Frances, we need an injunction.
We need to be in court on the 27th.
Yes.
Yeah. Good fun. But I think for all of the cases that we've done our emergency Christmas applications, we've had pretty good outcomes.
Yes, we're good.
Pretty good outcomes. I think the most recent injunction we worked on was a case, BFAM versus Mills.
An employment case.
It's an employment case. And that was due to enforce post-termination restrictions.
Yes.
Which there's a lot of debate as to the enforceability of post-termination restrictions. And very much when you're advising a client, you can't give them black or white advice because so much of it falls within the discretion of the judge.
That too, and also because in this sort of situations, the law is quite fact-specific, if you know what I mean. So even if you have the same set of terms, depending on the different context of the case, you may get different outcome.
Yes, and in that case, it was an IT guy at a hedge fund, and the technology that was involved, we had to learn from the scratch. We had no idea what all of these terminologies and technologies and everything else that the finance sector was using.
Yes, it surely was very challenging.
Very challenging to and also from your perspective, you need to educate the judge in a 2-hour hearing as to what all of this technology means, why it's so sensitive and why it needs to be protected. I
think I would put it in this way, that, well, it is a very, very deep learning curve, both for me and for a lot of different people as well, I'm sure, because of all these complicated technology. You have to explain them in a way that everybody can understand, and you have to fit them in the legal analysis. That is part of the challenge for a barrister.
And that is your skill. I don't think I'd ever be that eloquent to be able to distill something so complicated, put it into a context that could easily be understood to the judge, and do all of that within a few pages of submissions and 1 hour standing on your feet.
I do think, honestly, you have a great skill set in dealing with the client, getting instructions, etc., which I can never do in such an effective way.
Well, you're the one that tends to send me the message at about 11 o'clock at night to say, we need these loopholes to be filled. And I get to stay until 2 or 3 in the morning. And so you can read it over your 7 o'clock cup of coffee.
That's my revenge to you, Adam, for calling me before Christmas.
There are a few of the cases that we worked on together, and we've got a few more in the pipeline, which obviously due to client confidentiality we can't discuss. What cases have you worked on that have been either particularly instructive or particularly exciting that maybe I wasn't involved with? Well,
recently I have been quite busy with several arbitrations, but I can't really share with you the details. But all I can say is that there are a lot of disputes involving Chinese clients or Chinese contracts, and there is an overwhelmingly larger sector of cases where trials are conducted in Chinese. I'm talking about Cantonese or even Mandarin, so these are quite exciting new development on my part.
And you're seeing the preference for those sort of contracts is for them all to be pushed through arbitration?
Yes, and a lot of them actually choose Hong Kong as the seat. And choose Hong Kong law as the governing law.
Okay. Can you expand on why that may be?
I really don't know. But all the better for us, I guess.
All the better for us, indeed. Do you think that arbitration is preferred because of the confidential nature of arbitration? Or is it the way that enforcement works in China is much more straightforward than enforcing High Court judgments? I
would say the confidentiality, especially if you involve sensitive information about certain commercial contracts, and they value that very greatly.
Yep. I do find it very interesting, just to go back to the BFAM case. The client is telling you all of this sensitive information about their IT systems, and obviously part of the injunction is that they don't want this to be used by other people for their benefit. And so they're really hesitant to tell you all of their secret sauce. And we're drilling them down to say, you must tell us about the secret source. And the judge can ultimately write it into their judgment, which is a public document. And so I always find that balancing act between trying to get detailed instructions from a client when they really don't want to tell you the secrets, because the judge could write it up, to be quite tricky. I'm guessing that's the benefit of arbitration. Everyone could be just much more open with each other.
That's quite right. And when we deal with court litigation, of course, it is also down to us to make a differentiation of what sort of information to disclose. And sometimes you have to put in extra protection to those information, even though you're making submissions to the judge, for example, or disclosing certain facts in affidavits doesn't mean that they have to go into the public domain.
I see that you're extending your practice into contentious probate. I'm the employment lawyer at Hugill and Ip, and Alfred Ip, yours and my good friend, is our head of contentious probate. What attracted you to the sort of probate side of things?
In fact, probate has been one of my earliest fields, if you can put it that way. I was in the Nina Wang case when I just started practice. One aspect that attracts me about probate is not only that the legal analysis is often very intricate, but also the human nature reflected across the board of these cases. In order to conduct these sort of cases well, you have to have a good grasp on the human nature and to present the factual narrative of your case well, if I'm making sense to you.
Absolutely. It's a thing I enjoy about employment, because typically there's a company on one side and an employee on the other. And so there's a lot of human interest to the story, a lot of emotion, whichever side you're dealing with, and also the irrationality of people, which makes it quite exciting. Sometimes it makes it very frustrating, but it makes it quite exciting. It keeps each day different.
Yes, it makes it different from pure commercial cases. For example, you have to construe a contract in a very cold way. Then sometimes if you do probate, this is the exact opposite approach, where you always start with the factual narrative. That's really something that attracts me very much.
And are there any interesting probate cases you can share with us?
I have recently done a case where I have to prove an informal will.
Informal will? Informal
will. That means that a will that was not properly executed. There's no proper witnesses and there was no proper execution. So you have to prove beyond reasonable doubt that the piece of document represent the deceased testamentary intention.
And you do that by gathering historical evidence belonging to the deceased, getting testimonials from family and friends, and essentially building a case that way?
That's right. That was very challenging because you have to go through the minute details of his life and go through his documents and prove that that was what he wanted. And you have to prove it beyond reasonable doubt.
I'm guessing there's somebody on the other side who has a vested interest in this estate who is challenging you on this.
Yes.
Okay. Obviously, we can't talk anymore. Okay. Moving on to, I suppose, what some people might perceive as a natural development in your career. You're sitting again as a master in the High Court this time. Previously, you sat as a deputy district court judge earlier this year and a couple of years ago.
Sat twice. Yeah.
Sat twice, yeah. What insights do you get from being on the other side of the bench?
It was largely because having been in this profession for more than 10 years, I do really want to give back to the community by doing whatever public service that I can. And to sit as a deputy judge and do justice to the best of my ability is one way of doing it.
And I imagine it's a very different mindset that you need to approach it with, because as a barrister, your single focus is just fighting that case for your client as strenuously as you can. When you're sat on the bench, you've got two barristers in front of you, both fighting from their perspective. How do you change your mindset to sort of start balancing the arguments between and arriving at a just outcome rather than sort of doggedly fighting your one case like you would as a barrister?
You have to empty your mind and bear in mind how important it is to be fair. I think I can put it that way. You really have to be very fair and you have to listen to everybody before making your decision. You have to be very hardworking and read the papers. It is, I have to say, it is far more time consuming than one would think it takes to be judging a case.
I imagine. And the support that you get the papers presented to you that you get to read through, you sit in court, but then it's you that has to write up all of your judgments at the end of the day.
Yes, that's a lot of pressure.
And again, requires a lot of discipline to get these judgments out quickly.
Yes, and invariably you have to do it quickly because with time passes, it becomes more difficult. So after you hear a trial, for example, when the memory is fresh in your mind, then you remember everything and then you start writing. That is what I find helpful.
Good. And looking forward, what's the future for Frances Lok? More of the same, or do you see your career developing into a certain area, or is there a pull coming from certain legal areas that you're very attracted to?
I do enjoy what I'm doing, but if you ask me in terms of the development in general, I do see a great pull coming from the Chinese sector. I do see a great pull, say, the GBA area, Chinese trial, etc. There will be great potential development in the coming years.
Fantastic. Thank you very much, Frances.
Thank you.
Tune in and listen to more episodes of the Hip Talks podcast by checking the Insights section at www.hugillandip.com and the dedicated channels on Apple Podcasts, Spotify, Google Podcast and Stitcher. They are also available on Hugill and Ip's YouTube channel. You can send comments and feedback to the email address hello@hugillandip.com. Please share the Hip Talks with friends, family and business associates. This podcast is for informational purposes only. Its contents do not constitute legal or professional advice.